Welcome back to the High Court Report. Today, we dive into Olivier versus City of Brandon, a case involving sidewalk sermons and Section 1983. This prospective relief puzzle could fundamentally change how you challenge laws in federal court. The court hears oral arguments on December 3rd. We intentionally did this episode slightly out of order to start Monday with Trump versus Slaughter.
Here's what you'll know by the end of this episode. The Supreme Court will decide whether prior convictions create permanent shields, protecting questionable laws from future challenge. We'll explain exactly when Heck doctrine blocks your constitutional claims and give you specific strategies to preserve your rights even after criminal prosecution.
If you like our content, please subscribe, rate, and share the podcast. Your support allows others to access crucial Supreme Court analysis. Also, follow us on LinkedIn.
I want to remind our listeners about our upcoming first-ever mailbag episode on Black Friday, November 28th. I'm really excited about the chance to interact with you, the audience. This term delivered huge cases. You've got questions, you've got theories about how these cases connect. You want to know what I'm watching for in oral arguments, or which decisions could ripple through your practice area. Send your questions and comments by Monday, November 24th. Email us at scotus.cases.pod@gmail.com or message us on LinkedIn at the High Court Report. I'll read your message on air and dive deep into the answers. What's your take on this term's biggest constitutional battles?
Here's what makes this case critical for practitioners and citizens alike. Gabriel Olivier shares his Christian faith on public sidewalks. Mississippi passes a restriction. Olivier gets convicted, pays his fine, then sues to stop future enforcement against his religious expression. But here's the bombshell. The Fifth Circuit says federal courts cannot even hear his challenge because of his prior conviction. 8 judges dissent, calling this result absurd. Now the Supreme Court must decide. By December's oral arguments, we'll know whether past convictions create permanent immunity shields for potentially unconstitutional laws. This affects every constitutional challenge you might ever bring. Let's get started with Olivier and what the court will decide. First, whether Heck versus Humphrey bars Section 1983, claims seeking purely prospective relief where the plaintiff received punishment under the law challenged as unconstitutional.
And second, whether Heck versus Humphrey bars Section 1983, claims by plaintiffs even where they never accessed federal habeas relief.
Here's what you need to understand that you probably didn't before. Heck versus Humphrey creates a favorable termination requirement for certain civil rights lawsuits. You cannot sue under Section 1983 if winning would necessarily imply your prior conviction involved invalid proceedings.
But here's a key question. Does this rule apply when you only seek prospective relief, meaning you want courts to stop future enforcement but don't challenge your past conviction?
The constitutional framework combines First Amendment speech protection with Section 1983's civil rights enforcement mechanism. Section 1983 allows citizens to sue state officials who violate constitutional rights and recover damages or injunctive relief.
Gabriel Olivier practices Christianity by sharing the gospel publicly. Between 2018 and 2019, he regularly speaks with people on sidewalks near Brandon, Mississippi City Amphitheater.
In December 2019, the City of Brandon passes an ordinance restricting protests and demonstrations to a designated area during event hours. The law pushes speakers away from pedestrian traffic to an isolated zone.
In May 2021, Olivier returns after COVID reopening. Police order him to the protest area. He inspects it, finds it too isolated for effective communication, returns to his original location. The city charges him with violating the ordinance. Olivier pleads no contest, receives a suspended 10-day sentence, pays $304, and gets 12 months probation. In October 2020, while still on probation, Olivier sues in federal court. He seeks only prospective relief, preventing future enforcement against his religious expression. He explicitly avoids challenging his past conviction. The district court granted summary judgment for the city under Heck doctrine. The Fifth Circuit affirmed. But here's the crucial detail. The appeals court denied rehearing en banc by just 1 vote, with 8 judges dissenting.
On July 3rd, the Supreme Court granted certiorari. The court also grants the United States request to participate as amicus curiae supporting vacatur. Oral arguments occur December 3rd, 2025, with a decision expected by June 2026.
Let's walk through Olivier's three main arguments.
First, Olivier argues Heck doctrine doesn't apply to purely prospective relief. Olivier argues Heck reconciles civil rights lawsuits with habeas corpus by preventing prisoners from challenging convictions indirectly, but prospective relief doesn't attack past convictions. Olivier claims Heck created this rule because prisoners used Section 1983 damages, claims to challenge their convictions without going through proper habeas procedures. That concern disappears when someone seeks only future protection.
Second, the Fifth Circuit's extension creates a constitutional dead zone. Under their rule, anyone convicted under a questionable law never gets federal court review of that law's future enforcement. Think about the implications. Police departments could pass clearly unconstitutional arrest policies, convict one person, then claim immunity from all future challenges. That cannot be what Congress intended.
Third, Olivier's claims don't match malicious prosecution requirements. Malicious prosecution challenges the propriety of past proceedings. Prospective relief prevents future enforcement without questioning past prosecution decisions.
Now, Brandon's counter-arguments, which reveal their strategic thinking. First, Brandon argues both direct and indirect Heck bars apply. They emphasize Olivier received 12 months probation, not just fines. Winning an injunction would have shortened his actual punishment. This direct impact argument targets Wilkinson versus Dotson's distinction between challenging punishment duration versus seeking procedural improvements. Brandon claims this falls on the duration challenge side.
Second, common law history supports favorable termination requirements. Criminal convictions traditionally served as defenses to tort claims dating back to the 17th century England. Brandon argues law validity historically got litigated only in criminal proceedings or tort defenses, never through pre-enforcement challenges like Olivier attempts.
Third, Olivier's conduct demonstrably violated the ordinance. His group held large signs, used amplification, gathered in groups, and created safety issues requiring police intervention. The city argues Olivier cannot reframe demonstrative conduct as religious expression to avoid his conviction's implications.
The federal government's amicus brief supports vacating the judgment against Olivier for three primary reasons. First, prospective relief claims don't trigger Heck because they're not analogous to malicious prosecution. The government distinguishes damage claims challenging past convictions from injunctive relief preventing future enforcement. Second, no Section 1983 habeas conflict exists because Olivier doesn't seek release from custody or speedier release. The core concern driving Heck doctrine disappears. Third, even if malicious prosecution applies, Heck's requirements don't depend on custody status or habeas access. The favorable termination rule flows from claim elements, not procedural availability.
December 3rd's arguments will converge on several key areas. Watch how justices frame the core issue, speech regulation versus professional conduct. That characterization typically determines outcomes before reaching evidence or tailoring questions. Monitor questions about probation's impact. Does ongoing punishment change the analysis? Several justices will likely probe this distinction carefully.
Listen for broader constitutional concerns. If past convictions can immunize questionable laws from challenge, what happens to constitutional enforcement generally? Pay attention to practical implementation questions. How would courts distinguish legitimate prospective relief from disguised conviction challenges? This decision affects multiple practice areas beyond First Amendment law.
In criminal defense, whether a lawyer's advice about accepting a plea must consider future civil rights implications. Clients might want to challenge laws prospectively, even after accepting criminal responsibility.
In civil rights litigation, the decision determines whether prior enforcement creates permanent immunity shields for questionable government policies.
And in academic and policy work, the ruling may affect how constitutional challenges develop across all rights areas: speech, religion, due process, equal protection.
Thanks for joining us. Rate, Share and tell us which cases you want analyzed next. Your engagement helps us provide better constitutional analysis. On the next episode, we'll cover Ham versus Smith. This case examines whether, when someone takes multiple IQ tests to prove intellectual disability, must courts look at all the scores together, or can one low score alone save their life? We'll break it all down for you. Talk to you soon.